Well, welcome to Vicente end of year overview on intoxicating hemp regulations, where we are and what's to come. We were grateful to be joined by my awesome hemp team here and by our great friend and colleague and role model, Courtney Moran out of Oregon with Earth Law. And, intoxicating hemp has been a primary topic of discussion and, really interesting policy and debate this year as, the hemp industry is innovated, ahead of where FDA and the law is. So we've seen states take many different approaches or different stages kind of in the process and looking at how to regulate these products, where they should be regulated and how these interact with state cannabis regimes, and what's practical as far as regulation and enforcement in states where there aren't cannabis regimes. And then we'll also hit on federal law and what we can expect in the 2023 Farm Bill and how this may impact the regulation of intoxicating hemp. So we will jump right in and we'll save some time for questions at the end, but we are going to get a little bit in the weeds here on some of these topics. So if you have questions specific to a slide or a topic, feel free to put it in the chat and we'll try and hit it when it's relevant. And we'll have all of our contact information available too, so please don't hesitate to reach out to any of us as a resource. And all of the awesome attorneys on this call, specialize in hemp regulation and including, finished product, hemp product regulation and intoxicating and synthetic cannabinoids. So we are going to start our journey here in the state of Oregon with Courtney, and Oregon was one of the first states to really look at this issue, and like Colorado, is a state with a mature cannabis program, and that, I think desires to have good structures and support businesses in both markets. So it's a great first look at, how these type of laws have worked in practice and what's been effective and, where the challenge areas are. So I'll turn it over to you, Courtney, to give us the state of the state in Oregon.
All right, thank you so much. It's an honor to be here. I really appreciate all of the incredible attorneys that are on the webinar today and for how timely this webinar is. There's so much happening from a regulatory perspective, not only in Oregon, but across the country in multiple jurisdictions. And with the conversations being very focused on a federal level for the 2023 Farm Bill, it's really important that our industry participants understand that what they're doing in the marketplace is dictating where those conversations are going and what potential changes we are likely to see in the upcoming 2023 Farm Bill, which is what we will conclude the webinar with today. But so starting with Oregon, we've been working on cannabinoid regulations for several years now, and a lot of this stemmed from concerns coming from several of our agencies and also from our adult use industry with what they were seeing happening in the general market, which was causing potential threat to their own marketplace, but also with an overarching goal of public safety. And so when we went into the 2021 session, there were numerous bills pending, one specifically for hemp in regards to getting our state plan approved and the requirements we needed there, different pieces of legislation regarding enforcement, because, it's well known we had some issues with illegal cultivation within our state and outside of our programs. And then also, of course, with end products and what was being sold, where it was being sold, how it was being sold. And the result was House Bill 3000, which is an omnibus bill that incorporated several other bills and several pieces of policy that were negotiated between the hemp industry, the adult use industry, and our regulators and law enforcement. And a few key pieces that I wanted to pull out specifically for this webinar were the new terms that were developed through House Bill 3000. And so one important term was artificially derived cannabinoids, which I believe might be on the next slide here. I'll get back to these other definitions. But artificially derived cannabinoids, in OLCC's words, is a semi-synthetic cannabinoid created from chemical reactions with a cannabis extracted substance. So Delta-8, CBN, for example, made from CBD. Now, this does not include any materials through traditional extraction or decarboxylation, but created this new category for how these different cannabinoids were being classified. Now, another important definition is total THC, or total Delta-9 THC. And that definition is reflective of the USDA final rules in incorporating the THCA with the 0.877 factor plus the Delta-9 to encompass that total THC. And so that applies in Oregon not only on the farm level, which is, we've had in place since at least 2020 or since 2020 for production, but for end products as early as 2018. So this is not a new concept for Oregon, yet some folks within the industry, failed to understand that nuance about the difference between what was happening in the field versus our end products. And so I wanted to point out, because I think it's really important for folks to understand that criminal codes have been in place, but they were also updated within House Bill 3000. And previous to 3000, it was unlawful to import or export any hemp products or any cannabis products that was above 0.3 total THC. We did have a small victory and increase that to a 1% total THC concentration within House Bill 3000. But I want to note that I've been seeing that there's high THCA flower that's on the market and being marketed as hemp. And while there's different nuances on legal interpretations of the potential legality of that flower, in Oregon specifically, it is a crime to import or export any material above a 1% total THC. So if there's THCA flower, for example, that's above 1%, that is a crime, and it ranges from a Class A misdemeanor to a C felony, depending on the quantity of material that is imported or exported. Now, a couple of the other definitions, specifically more toward product sales, is adult use cannabinoid and adult use cannabis items. And so adult use cannabis items are marijuana items or hemp commodities or products that exceed 0.3% total THC, so again, incorporating that THCA, or the concentration of adult use cannabinoids, meaning tetrahydrocannabinols, they're acids that have an intoxicating effect, such as Delta-9, such as Delta-8, and any of their isomers. Now, one piece, I did not put this on the slide, I just want to comment, was that as soon as House Bill 3000 became effective in law, there was an emergency rule issued literally the next day regarding product sales to minors. And so as of July 2021, hemp products can only be sold to minors as long as they contain less than 0.5 milligrams of total THC, including all isomers. So that's been in place for 1.5 years now. But in regards to general product sales, not product sales to minors, after 3000 went into effect, we went into several months of Rules Advisory Committee meetings and into formal rulemaking with OLCC, our Oregon Liquor Cannabis Control Commission. And through that, they put in place allowable amounts of THC in products, both for products in the general market and also products for sales in the licensed dispensaries. Those rules became they were adopted on December 28th of 2021, but they went into effect on July 1st. And so you can see with these charts here, there is a difference between what can be sold in the general market. It's lower amounts of total THC in the products versus what can be sold in the dispensary. But this is the current law of the land here in Oregon of what products can actually be sold in the general market. And so something important to note, not only about these charts, but about the new rules that were adopted, is that sales of any intoxicating or non-intoxicating artificially derived cannabinoids became prohibited for sale in the general market as of July 1st of 2022. So you can no longer purchase Delta-8, you cannot purchase CBN products in the general market here in Oregon. There is a short time where you can purchase, for example, CBN within our dispensary system, but those are not allowed anymore in our general marketplace. And one caveat that's been really important for the industry here in Oregon is that our hemp handling or our hemp manufacturing and processing is regulated by our Department of Agriculture. It's not regulated by OLCC. So one can manufacture the products here in Oregon. They can produce Delta-8, they can produce CBN and these other artificially derived cannabinoids. They just cannot sell them here. So if a business wants to manufacture these products, they can still do so in Oregon. They have to, again, comply with those import and export THC limits, but then they just cannot sell those products here in Oregon. And along those lines, I just want to note for anyone that is in Oregon and operating, there has been an update to our hemp handling rules. And so anyone throughout the cannabinoid value chain, so not only that initial processor, but anyone throughout that processing value chain is now required to get a hemp handler license. Those applications are available, but that requirement will go into effect January 1st. So it's very important that if you're doing any sort of manufacturing of cannabinoids within the state of Oregon, you do need to have that hemp handler license. Now, one other piece that came out of House Bill 3000, you can go to the next slide, and I will say I could spend a whole, several hours just talking about these rules, was the task force on cannabis-derived intoxicants and illegal cannabis production. The task force was originally 15 members. It was expanded in the 2022 session to 20 members. We began meeting in May of 2022. I was appointed by Oregon Governor Brown to represent hemp growers throughout the state. And we had our last meeting on November 28th. We met numerous times as a full task force. We had a breakdown of several subcommittees focused on law enforcement, on cannabinoids, on natural resources, and on funding. And we put together, the collective of the task force put together a report and a list of recommendations to our 2023 legislature. And this final report actually just became public Monday of this week on December 12th of 2022. And so the pieces for topic of today's webinar that I want to highlight are the cannabinoid product registration. So this is a proposal going forward to create a product registration that would be administered by the OLCC because they already handle product registrations for cannabinoid products within the state on the adult use side. But this would be for all hemp products, both for hemp human consumption and animal consumption that contain cannabinoids that are being brought into the state, whether it's online or sales in an actual retail facility. It does not apply to any topicals or grain or fiber products, but it would also require a label review. And so one thing that was pointed out throughout the development of the task force and our discussions was that we do not have any required hemp labeling specifically in Oregon yet. That is another recommendation that is going forward to the legislature to provide that regulatory authority to OLCC to develop adult use and hemp labeling specific requirements. So that is something that we hope will ensure additional product safety and provide clarity for what products are on the market along with this product registration. And so it's important to know that the intent is not to create any additional burden or any significant additional cost to folks selling products into Oregon, just really to make sure that not only do our regulators know what products are being sold, but that our consumers are having access to information and having safe products and accurate labeling on the products that they are purchasing. And the other piece from the task force is the development of a state reference lab. And so that would be formulated through our Department of Agriculture, funding from our legislature to help with enforcement for testing standards and just general laboratory oversight. So you can find more information about the task force through the Oregon Industrial Hemp Farmers Association and the work that we have done with the task force. But for today, that's a general overview of where we're at in Oregon. But I do encourage folks to look at that task force final report and also to track this upcoming 2023 legislative session, how these recommendations are received and implemented by the 2023 legislature.
Thank you. Quick questions on Oregon before we move on. Did Oregon discuss these products with respect to online sales and e-commerce and any potential for enforcement there?
Yes, that was part of our conversations during the task force, and that will be part of the required product registration.
You have to register even if online.
Yes.
And then would the product registration process apply only to imported hemp products into Oregon? It sounds like it would be broader.
Products being brought in, and products are also sold directly from manufacturers within the state.
Okay. And then kind of similar question to the first one, even if the registration is required for online sales, do you think these enforcement resources are going to really give them the ability to enforce against online sales, including like the sale of Delta-8 or Delta-9 on Amazon, where there's no age gating?
Yeah, that's a fantastic question. And that's something that enforcement is something that we've talked about a lot, both in private conversations with the agencies, within the task force, and with members of the legislature. There is a fee increase on the ODA side this year to help manage the costs. That will definitely be going toward enforcement. I know OLCC is stepping up their enforcement, and specifically in regards to hemp handling and manufacturing, that is something that our Department of Agriculture is going out there doing inspections. They are engaging in enforcement. And because of the very serious concerns that have come from our legislature, our law enforcement, and our agencies, that with this product registry, that is an avenue for them to start really tracking what is going on within the state, and any products that they find that are not included within this system, that I will say has to get yet approved by the legislature and go through rulemaking to be adopted, but will be the mechanism for enforcement. So I do think, yes, that they, they're not putting in place just to do it. They want to have the enforcement and have the mechanisms in place to do so.
And I know that's the discussion happening, and these discussions are happening in Colorado and other states too. And I think there's an understanding that, with a lot of the regulatory regimes that have been developed before, the lack of enforcement, didn't really allow them to be successful in practice, specifically with online sales. So in many states, I think more enforcement resources are being allocated, and also to consumer protection agencies and state attorneys general. So I think we'll see some increase, but whether there's so much on the internet, I think it is going to be challenging. And one last question on Oregon, and then I want to move on to other states. Is the task force recommending the ongoing ban of ADCs, artificially derived cannabinoids, in the general market?
Yes, we did not get into too much specifics on that, but through additional rulemakings, yes. And there's been no real dialogue on changing that. There's some conversations on non-intoxicating ADCs, specifically on CBN, so that we may see a change with CBN, but other ADCs, I think it's unlikely to see a change.
And is HHC included as an intoxicating cannabinoid?
It is, yes.
Thank you so much, Courtney. I think, Oregon's a little further ahead than some of these other states like Colorado and California coming and looking at these same things. So really interesting to see how it's playing out. I think we'll move on down to California with Andrea. I'll turn it over to you to give us the state of the state there.
Thanks, Sean, and thanks, Courtney. And I have to say, it's not often that I say that California law is less complicated than other states, but it is certainly less complicated than Oregon. Jen, you can go to the next slide. Thank you. So, California created a regulatory framework for hemp products last year in October of 2021 through the passage of AB 45. And AB 45 includes a definition of THC that is inclusive of THC as well as any other THC, including Delta-8, Delta-9, Delta-10, however derived is the language used in the statute. In addition, the definition of THC also gives the California Department of Public Health discretion to add any other cannabinoid that it deems intoxicating to the definition of THC. It also has discretion to exclude isomers of THC from the definition of THC. So it's a really broad definition that gives CDPH a lot of power through rulemaking to include or exclude THCs or other isomers as it sees fit. And when it comes to hemp products, so the standard for hemp products is, it's a combined THC standard. So it's 0.3% THC for either the hemp extract or the final product. It's, again, a total THC concentration of 0.3%. So that's, again, in the statute, it refers to D8, D9, and D10. So clearly we can infer from that you can put Delta-8 or Delta-10 into a hemp product, but you're subject to those to that 0.3% total THC limit. There's also, a definition in there for industrial hemp, and it says, industrial hemp does not include cannabinoids produced through chemical synthesis. But of course, chemical synthesis is not defined in the statute. You can look elsewhere, you can look at case law, you can look at AG opinions for other drugs or other controlled substances. And chemical synthesis has generally been defined mostly by the courts as the production of a new compound by adding to or subtracting from or changing the structure of a precursor compound. So that would seem to include cannabinoids like Delta-8, but it remains to be seen what CDPH is going to do through regulation. But at this point, this is the law as it stands currently.
That's me. Hi.
Get on mute. Thanks, Michelle.
Yeah.
Oh, sorry, quick question on California before we jump into New York.
Yeah.
Percentage based on weight, how does is that meaningless for edibles? The loophole that is that issue in general?
Yeah, good question. Yes, and maybe that's something that we will see in future regulation is an actual milligram serving size or package limit. But at this point, yes, you can have a 0.3% product that has, a lot of milligrams of THC in it, the way the law is currently written.
CDPH does have the authority to address that, correct?
Absolutely.
Yeah, I anticipate that would come. It would.
I think so too. I think they're watching closely. I think they're watching Colorado. I think they're watching Oregon, and I think we will see those regulations coming down the pike.
Yeah, thank you. All right, New York.
Sure. Next slide. Thanks. So New York, I would say, passed their hemp law a few years ago. Their rulemaking has gone through 3 different iterations over an 18-month process. But one thing that has been consistent since the jump has been that they do not want synthetic cannabinoids or cannabinoids made through isomerization. So they're hyper-focused on that aspect, not necessarily the intoxicating impact or effect. And, they specifically call out in their regulation and in their laws talking about those products such as Delta-8 and Delta-10. Of course, they're just examples and not supposed to be the laundry list. But one thing New York is doing different, while they talk about hemp products cannot contain any synthetic cannabinoids, they also then include a list of cannabinoids that are permitted as long as they're derived from hemp, regardless of their manufacturing process. So slightly at odds. So a lot of states sweeping CBN up in some of the artificial cannabinoids or synthetic cannabinoids, whereas New York is saying you can't have artificial or synthetic, but also you can have CBN. So a little bit of a dichotomy there, but at least good news, the laundry list of cannabinoids. And these are all spelled out in regulation, which selfishly, when we do research and we're looking for specific cannabinoids, I certainly appreciate that New York bothered to name them all. So it's expressly permitted. And this is the laundry list you see on this slide. So CBN, again, being just to pick on that, cannabinoid expressly permitted. One thing New York does, and we just talked about, California and the scope of their jurisdiction and what may come, the regulations in New York do say the New York Office of Cannabis Management does have authority in future regulation to impose a total THC cap, which would include detectable levels of total Delta-9 or Delta-10, and that will be a milligram per serving and per package. So they've kind of given themselves the option, but kicked the can down the road. And then in terms of enforcement and what's going on the ground, New York, like some other states, their cannabinoid hemp program is regulated by their cannabis agency. So New York is a little bit late to the standing up their adult use cannabis program, but eventually they'll have plenty of fees and it'll be the same agency enforcing against these hemp retailers. So far, all they've said is issued a warning letter to a kind of an advisory to their registered hemp retailers saying, please don't forget, you're not supposed to be selling Delta-8, but it was just a letter and it was only to those retailers throughout the state that has gotten, although it's required, the hemp retailer registration. So, essentially wagging their finger is all that's happened to date. But it is anticipated once the enforcing agency has, all those cannabis licensing fees, they'll be in a much better position to do any enforcement should they choose. So that's kind of the state of the play. Legislation starting back up in January, but unlike other states, we're not really anticipating this becoming a hot button issue of something going to be looked at, but you never know who is really passionate about this topic and who wants to file a bill on the topic.
Michelle, what about the per package limit, the cannabinoid limit?
Yeah, so for right now, for a cannabinoid hemp product, if it's a food or beverage, it can't contain more than 25 milligrams of total cannabinoids, so not THC, just total cannabinoids per individually packaged product. And then if it's labeled and marketed as a dietary supplement, it can't contain more than 3,000 milligrams of total cannabinoids or 100 milligrams per individual serving. So they want total cannabinoid, not necessarily a THC specific limitation.
Got it. And then same question coming about e-commerce, and I think this is relevant in every state. I don't know of any state that's been able to well enforce e-commerce. I don't know that New York's any different.
No, I mean the only thing is in New York, if you are selling any cannabinoid hemp products to a customer located in New York, you're supposed to register as a retailer. So in theory, you follow that to the T, you're on their radar. And you would be able to, easily get a warning letter or something should they choose. That said, we've communicated with OCM and said, if someone is selling a Delta-8 product off their website, is that grounds for denying a retailer registration? And they said, no, we're not looking that closely right now.
Yeah, I think it's in so many of these states a matter of resources too. One last question on New York. Is there concern or the expectation that they'll not differentiate between synthetic cannabinoids and synthetically derived cannabinoids?
No. At this time, I haven't seen anything that nuanced, but again, their laws are about, at this point, 2 years old. Regulations, although we've gone through a few iterations, more than 18 months old. So I do think, if there is a change, they might learn lessons from other states and start being a little bit more splitting hairs with terms and definitions.
Yeah, states have really struggled with these definitions, and it's difficult. Ideally, there'd be a federal definition, and now having multiple state definitions of terms like synthetic and intoxicating is very difficult, I think, for businesses and enforcement and consumers. Great question to segue into Colorado and the discussions here. Why would people sell hemp derivatives like Delta-8 in legal marijuana states? I think they're able to sell online and in other venues besides marijuana stores, and it's lesser of a cost. So there's just a bigger market. But in Colorado, that's really a big topic of debate, as it was in Oregon. What, from a public safety perspective, should be regulated and the marijuana system and, you know, what is more appropriate and what was intended in the hemp regime. And, you know, it's been a really an interesting and informed debate. So we'll jump into my state here, Colorado. Hit the next slide. And Katie, do you want to give an update on just the state of the law kind of going into the task force?
Sure. So we all know Colorado is going through some changes right now, but I'm going to start with kind of how we got here and how things started. So on May 14th, 2021, CDPHE, which is the Colorado Department of Health and Environment, sent a notice to stakeholders announcing a policy prohibiting the production or use of chemically modified or synthetically derived cannabinoids in industrial hemp products. So CDPHE was concerned that a complete profile of reactionary byproducts had not been established in association with the conversion of these cannabinoids, and said, you know, you're not allowed to put them in food, dietary supplements, or cosmetics. They did call out specifically Delta-9, Delta-8, and Delta-10, but the policy itself kind of swept up other cannabinoids such as CBN. And they actually did on June 7th, 2021, CDPHE held a webinar explaining the policy statement and explicitly stated that CBN is prohibited under that policy. However, we haven't seen as much enforcement against CBN, but they do consider, under this policy at least, CBN to be a chemically modified or converted cannabinoid. So then moving forward, during the 2022 legislative session, Colorado passed SB 2022-205, and the bill's purpose was to regulate cannabis-related products that are synthetic or intoxicating. And the bill kind of did four main things. So it authorized CDPHE to promulgate rules to prohibit chemical modification, conversion, or synthetic cannabinoids in final products. We haven't seen those rules yet. They'll probably be related to the recommendations in the task force, but it did give CDPHE that power. It also directed the Marijuana Enforcement Division to create a task force to study intoxicating and synthetic hemp products. That task force is going to make legislative and regulatory recommendations. And the report is due on January 1st, 2023. And I think Sean's going to dive in a little bit more here in a bit as to what's being discussed in that task force. The next thing it did was it added a new provision to the consumer protection laws, and it actually made deceptive trade practices relating to hemp specifically is considered now a violation of consumer protection laws. And then it dispensed more money to the Colorado Attorney General, specifically to enforce those consumer protection and antitrust laws specific to hemp products. So that's kind of that private enforcement area that we were discussing earlier. You know, it's, as we were saying, it's very difficult to enforce against products sold online. And I think that's just one more tool in the toolbox to kind of allow regulators and, you know, the Attorney General's office to take a look at those online products.
Thank you. And yeah, this was, you know, going into the task force debate, and now the task force is wrapping up now. You know, it's had a really interesting debate with a lot of smart people from all sides, and you know, I have a much better understanding of both the science and the policy. So it's been, I think, a useful process. The report is due January 1st, so we're sort of at the end of the process here. And really what the task force is proposing is a broad system for categorizing various known and unknown cannabinoids as far as how they'll be regulated, kind of like Oregon, having a non-intoxicating and intoxicating distinction, with intoxicating only being allowed in marijuana stores. Non-intoxicating hemp will include CBG, CBD, CBC, CBN, full spectrum, and broad hemp extracts. And those can be, you know, used as ingredients and allowed for sale in the industrial hemp regime. And potentially intoxicating cannabinoids are novel cannabinoids, which we're not sure are already classified as non-intoxicating, and non-phytocannabinoids, and they wouldn't be allowed to be manufactured within Colorado unless they're assessed by the agencies through a review and approval process, unless they're subject to a safe harbor where there's certain exceptions. And then intoxicating cannabinoids, which include all Delta THC isomers, metabolites, and synthetic forms, would be not permitted to be manufactured within Colorado or used in industrial hemp products until they go through the appropriate assessment by the agencies to assess safety. And the safe harbor is a temporary provision for hemp producers to manufacture cannabinoid products that are not yet approved for sale, to allow to export them to other states where they're legal. So it would allow, Colorado companies to keep their businesses in the state as they work to become compliant with regulations over time. And this would only be allowed if they comply with certain safeguards. And this is similar to what happened in Oregon, where businesses weren't allowed to sell products under the new regulatory regime within Oregon. They were allowed to sell them out of state. And another thing the task force is recommending is the formation of a standing scientific review committee, or an expansion of an existing one, to work with the agencies to evaluate the safety of intoxicating potential of new cannabinoids. I think, one of the things we're hearing from regulatory agencies across the country is there's so many unknowns here, and they really want more information. And, we're only recently, as of 2014, allowed to legally research the hemp plant. So we're just learning a lot at a fast pace, and there's a need for science to inform the regulators. So the committee would have an academic and scientific focus with subject matter experts and some, but probably minor industry involvement. And the task force is also proposing that hemp products have an initial serving size cap of 2.5 milligrams of THC per serving, and a minimum ratio of 15:1 non-intoxicating cannabinoids. And this was a compromise to ensure that high potency but full spectrum or broad spectrum products that are used for medical purposes are still allowed here. And there are also several safeguards embedded in the cap and the ratio to protect public safety, and broad regulatory authority of agencies to adjust the cap in the future. And then again, on enforcement and having the ability to police this and online sales, recommendations for broad regulatory and rulemaking authority that can grow along with the science, and obviously any FDA or federal guidance that would require an adjustment. And then a recommendation that the agencies and Attorney General's office be provided with resources to support enforcement. It also includes label and marketing requirements, and advertising and other restrictions in the recommendation. So there will certainly be legislation in the new year in Colorado to implement the recommendations in the task force. So much of this is subject to change, but this was a very robust stakeholder process. So I expect that many of these recommendations will be respected. Are any of these states tracking medical incidents associated with hemp derivatives? Is there data on that anywhere? Yes, to my knowledge, a number of these states are tracking adverse events, and there's also some other organizations that have tracked them, and FDAs as well. They've cited some in their advisories around Delta-8 intoxicating hemp. I'm happy to share some of those resources as well.
Sean, I have a question for you. Is that a 15:1 ratio? Does that mean that you can't have a product that has 2.5 milligrams of THC and no other cannabinoid? Is that what that means?
Yeah.
Okay.
Moving on to federal, and I think states are realizing, and more every year that they manage this, that it's up to them to ensure public safety, because the FDA is very slow to act, and their enforcement continues to be minimal, but it's there. And Progress in Congress has been very slow. So states have been, sort of tasked with being mini FDAs, which is a challenge, but also, we have some state laboratories that will hopefully inform good federal policy in the future. So federal enforcement, is focused on FDA's continued enforcement priorities, and they're in partnership with, state agencies and the FTC on enforcement. There's been a number of advisories against Delta-8 products, and they issued a notice. The 5 things to know about Delta-8, where they cite some of these adverse events and concerns about product safety, including THC content and adulterants and contaminants, but also products that are marketed towards children or product types and packaging. Also packaging that just generally false and misleading. And there was a recent batch of FDA warning letters that came out this month, including one on Delta-8, which were interesting. And I think could be a signal of increased enforcement, given the rise of intoxicating and synthetic hemp products. And these included some interesting things like the impact of CBD on caffeine metabolism. Certainly an emphasis on products that are appealing to children or false and misleading. Address products containing cannabinoids other than CBD. A focus on pet products, which has happened in the past as well. And they notably did product testing. They cited Facebook posts from several years ago. They're looking at all sorts of different marketing. Whereas the FDA on other intoxicating hemp cannabinoids like HHC, their position would be that none of these are approved as legal and safe as ingredients in food and dietary supplements. And I think they would take the position that some of the THCs are subject to the drug preclusion. So probably similar to their advisory on Delta-8, I would expect similar safety concerns, and some even greater where, there's some of these THCs have, more potency than Delta-9. And then there's important bills in Congress where I expect there will be more progress than with the FDA. So I'll turn it over to Courtney to kind of hit the federal legislative overview.
Thank you. Yeah, it's interesting to see back to back the different definitions and the landscape of how things are developing. And I think a lot of us would like to see some clarity and consistency coming from the federal level so that we can stop having this, 50-state patchwork. Now, there are, of course, several pieces of legislation that have been pending for the past couple of years in regards to CBD regulation and some hemp-derived cannabinoid regulations. But really the only piece of legislation that we've seen introduced so far that's really talking about intoxicating potential cannabinoids is the Hemp Advancement Act, which is HR 6645, sponsored by Representative Pingree out of Maine. There was a lot of excitement around this bill pre-introduction and as it was introduced, especially with the change of definitions, but we really have not seen any movement around this piece of legislation. Representative Pingree remains the sole sponsor for this piece of legislation, and her staff has said that this is really more of a conversation piece about topics that could be addressed in the upcoming 2023 Farm Bill. Unlikely to have this exact text adopted, but potential pieces of this bill text included in the upcoming Farm Bill. I just want to make a side note that Attorney Shane Pennington wrote a really great blog post about some of the concerns about this particular piece of legislation and the way that it was drafted. And I do encourage folks to look at that just to get a different perspective and oversight on the bill text as a whole. But for the purposes of this webinar, I want to point out a few important pieces, and a couple of these are included here in the slide, but I want to dive in a little bit more specifically. And so, of course, one thing I think pretty consistently across industry is that we all would like to see that 10-year felony restriction removed for those that have controlled substances felonies. I hope that we do actually see that in the final 2023 Farm Bill text. So that's a really key piece of the Hemp Advancement Act. Also, the removal of the DEA registered laboratory requirement for testing labs. USDA did, of course, just recently extend the applicability of the extension to not have the DEA lab requirement until 2024. So at least there's movement on the regulatory and rulemaking side. But of course, again, we would like that clarity again in the upcoming 2023 Farm Bill. But more specifically in regards to the topic for today is regarding total THC and the actual THC limits within products. And so a few new definitions are proposed within the Hemp Advancement Act. There's a proposed change to the current definition for hemp, which would increase the allowable THC concentration to a 1% total THC. I think that's something a lot of us have been advocating for a long time. So, there's a lot of hope that we can get that movement, especially for the folks at the farm level. There was also a new definition for hemp extract. So the material actually used in the making of a hemp product, not a finished product that's intended for sale, but a hemp extract that has a total THC concentration above 1% total THC. So those work in progress type products and materials. There's also a new proposed definition for hemp product. So it's a definition for finished hemp products with a total THC concentration of not more than 0.3%. But most importantly, in encompassing the changes to and development of those other definitions is the clarification of what total THC means. And so we received that total THC definition in the USDA interim final rules and final rules. But this would be a change federally to create a total THC definition that's an aggregate concentration of Delta-8, Delta-9, Delta-10, and optical isomers. And so potentially with the other developments of other cannabinoids, intoxicating cannabinoids on the market, that definition could be broadened. But really, I think that when we're thinking about what are potential changes that we're going to see on a federal level, especially based on the changes that we're seeing in so many different states and how the market is continuing to evolve to include different types of intoxicating products, so-called coming from hemp, that I think we can expect to see a change to a total THC standard that is more broad and encompassing of the isomers in the upcoming 2023 Farm Bill.
Thank you. And a couple of questions in the chat, and we can kind of move to Q&A. I think that's the last slide, right? But I think you addressed, but to clarify that the Hemp Advancement Act, oh, now we have to address the percentage loophole in final and finished products. I think it would address the percentage loophole by adjusting the total THC concentration, right?
Yeah, definitely. I think a lot of the gaps can be clarified specifically by an update to a definition that's much more clear.
And then there's still, in active legislation that would specifically address finished products. There's 3 bills: the Hemp Access and Consumer Safety Act, the CBD Product Safety and Standardization Act, and the Hemp and Hemp-Derived CBD Consumer Protection and Market Stabilization Act. And essentially these bills in various forms would remove the drug preclusion, which is the provision of the FDCA that basically says CBD and THC can't be legal ingredients in food and dietary supplements because they were ingredients as drugs. And then they would, give the FDA the authority to, under its existing framework, to, impose specific packaging and labeling recommendations, but allow hemp-derived cannabinoids a path under the existing food and dietary supplement framework. Some of these bills only allow the dietary supplement pathway. The Senate Bill 6098 is limited to CBD and dietary supplements. HR 6134 is food and beverages and dietary is food and beverage. And HR 841 is broader than CBD. It's also, essentially non-intoxicating hemp ingredients. And then, subject to the FDA's regulatory framework. Despite bipartisan support, there hasn't been much progress on these bills. So, hopefully more progress this year, with the new Congress. But, I think the industry is going to have to continue to really make a robust effort here to move these things forward. Predictions for 2023, we can kind of go around the horn here and then we can move to questions. My prediction is we'll see more states, especially those with cannabis and hemp regimes, have these task forces and adopt pretty advanced, cannabis regulation for hemp and marijuana that, really has two regimes for intoxicating and non-intoxicating cannabis, and also addresses synthetic and chemically derived products. And I think it's going to be a challenge with multiple definitions of these complicated terms. Courtney, what are your predictions?
Yeah, my predictions on a state level, I think, as you said, more states will go into developing task forces or committees to review what's happening within their state, potential changes in either rule or statutory text. I believe that there will be a lot more resources spent on enforcement and ensuring that the laws are carried out, because we've seen with the lack of enforcement, it's what's creating some of the issues that we're seeing state by state. And on a federal level, I think we could definitely expect to see a broader definition for hemp that is encompassing of total THC and really clarifying that. And also a move that's creating a delineation between grain and fiber and cannabinoid and floral hemp, such as for the hemp exemption.
Michelle, what does your crystal ball say?
In a surprising change of pace, I'm going to go positive. So I think there's going to be a lot more innovation. I mean, I think we're already hearing about people that are making these cannabinoids through novel means that maybe aren't actually technically synthetic, and rather consolidation of Delta-9 or other methodologies. You're hearing about new genetic strains coming online that wouldn't actually then apply to some of these prohibitions. So I think as states continue creating a patchwork and people playing whack-a-mole, there's always someone out there who's innovating and being more creative in the industry and trying to be as compliant as possible, while also coming up with new genetic strains as well as methodology to create these products.
Great point. Andrea, what do you got?
Yeah, so I certainly agree with Courtney that we're going to see a revised definition of hemp in the 2023 Farm Bill, in an effort to stem the tide of intoxicating products being available anywhere and everywhere. I think on the state level, states are going to become more strict, in response to this, these high THC products being sold all over the place. I think we're going to see more requirements for, child resistant packaging and age limits, for all hemp products, not just, high THC or, DA products. I think we're going to see more of that, those sort of protective pieces of legislation next year.
Agree. Katie?
I think, we've been talking, it's kind of been a theme throughout this webinar that enforcement is an issue. I think we're going to see states trending more towards like Colorado did, where we bring in consumer protection laws and the Attorney General's office to kind of try to enforce these laws, and potentially with private rights of action too. I think it's really the only way that there can be any meaningful enforcement, especially against online sales.
Yeah, that's a great point. I think enforcement is such a big piece of this, but I think more and more of these states are really understanding and practice. So great predictions. And we've got 5 minutes, so I'll hit as many questions as I can.
Can we, Sean, just sorry to interrupt. Can we hop back? I think we skipped over Farm Bill discussion in a little bit more detail about what we think, will and won't be. And I think we got a few questions that came in as a result.
Yeah, thank you. Sorry, I didn't realize you missed it. And one of the questions is when the Farm Bill rules go into effect. So, I know there's some uncertain timing as to when the Farm Bill will happen in general. You can speak to that.
The Farm Bill will go into effect once it's passed, right? So negotiations are just starting. If we can look to, the past two Farm Bills, they took a while to negotiate. And so the 2018 Farm Bill, a lot of the language and standalone bills were introduced in that early Congress. So we can expect those for the first few months of the year. Then we'll see, a draft come out of the House and the Senate, and then they'll have to negotiate to a final bill. So ideally, we'll see it by the end of 2023, but I don't think anyone can say specifically.
Yep, and they're just to piggyback off, they're every 5 years, and they have been since the 30s. But I'd say probably every, I don't know, Courtney, every 4 or 5 cycles, they kind of miss the mark, and they have to do kind of an interim, appropriation to carry over funding until they can finish negotiations. So ideal world, end of 2023, but not outside possibility kicks into 2024.
Right. And then once the bill is adopted, of course, the agents, USDA is going to have to go into rulemaking after that, just like they did with the last Farm Bill.
Right. And the current Farm Bill expires September 2023.
And there is expectation that the DEA lab requirement, which is just extended for another year to the end of 2023, will be removed. But I understand that could also just be in separate DEA rulemaking or separate legislation. And there's a question, with respect to the Farm Bill not including finished product regulation, is that a certainty or speculation? I think there's no, total certainty because we just haven't seen it yet, but the USDA's jurisdiction, is not over finished products. So, I think they're limited in what they can do, but I think there, can be delegations of authority and a lot done as far as, adjustments to definitions that will support finished product regulation. Some other questions here. Any clarity on minor cannabinoids besides CBD and THC content in smokables that might have intoxicating properties in smokable products that must be tested also before sales? I would say that some states have more regulation over smokables than others, but including in Colorado, it's a little bit of a gray area as far as the smokable finished product regulation.
Yeah, and I'd say most states that are banning or restricting these cannabinoids are not drilling down at the product level. Most are just saying, regardless of the product type, we don't want this in our state.
Yeah, and there is a number of states that ban inhalable products as well.
Yeah. Michelle, this one's for you. In regard to the New York product limit, does this mean that no product containing more than 25 milligrams of any cannabinoid or combination can be sold in a retail store?
Correct. If it's 25 milligrams, it's a food or dietary supplement. And if it's a dietary supplement, total cannabinoid limitation is 3,000 milligrams total cannabinoid per product with no more than 100 milligrams per serving. And retail sales, including online sales to customers located in New York.
Does any state have age requirements for purchasing Delta-8 products? Yes.
Yes.
And I think that will increase. Take one last one.
And I'd argue Rhode Island and a number of other states, depending on the product type, have age restrictions even for non-intoxicating. Rhode Island's 21 plus for all cannabinoid hemp products.
Yeah.
And we advise even where it's not required that it's a best practice, consistent with, consumer safety best practices. Last question. Anyone does anyone have comments on the Delta-8 treatment by regulators in Florida and Minnesota, which of course are permissive?
Well, I would say at least with Minnesota, they do have pretty strict requirements on their permissive use of or permissive allowance of sale of Delta-8 or higher THC products. At least they do require that purchasers be 21. that the products are in child-proof containers, you know, and that they're manufactured safely. So I will say that about Minnesota.
And in Florida, I believe that the Delta-8 is stance is just a policy. It's not in law or rulemaking anywhere at this point. So, you know, that could change at any time. But they do require that any products, you know, meet all other requirements for other hemp products, like labeling and testing and all those things.
Well, thanks so much, everyone. We're right at 1, and I really appreciate everyone's time and attention and really great questions. And all of our emails are, sorry, Courtney's isn't here, but we can put it in the.
I'm putting it in the chat. Yeah,
Sorry, it was supposed to be in there.
that's okay.
Please don't hesitate to reach out to any of us. You know, these are all, it's very tricky policy, so we're really interested in your thoughts and feedback, and really appreciate you taking the time. And thanks to all my awesome colleagues for the wisdom and time as well.
Thanks, everyone. That was great.
Thanks, guys.
Thank you.
everyone.